We're live.
All right, good afternoon. This is the House Judiciary Committee. It's March the 16th, 2021. And it's a voting session. One of the voting sessions we will have this week. We will begin. No, I don't have that. Do I? I will begin. We're going to start with House Bill 242. House Bill 242, Delegate Atterbury's bill. We've heard this bill before. And Delegate Atterbury, tell us what it does. The Vice Chair.
Thank you, Mr. Chair. So essentially, oh, I was like, I did something and all in black, but that was Dylan. Okay. So essentially, the bill puts parameters around a 17-year-old that wants to get married. The court has to find that they have been emancipated. The court has to conduct an in-camera hearing and make a written determination of several factors that are spelled out in the bill, including that the individual can't be more than 4 years older than them. The court will appoint a lawyer, set a hearing, provide the minor with information about their rights and responsibilities, give them information where they can get legal counsel if they want to. During the in-camera interview, the minor's parents will not be there and the intended spouse won't be there. So the person petitioning the court, the 17-year-old, will be there. And the judge has to make written findings that person is a resident of the county, the intended spouse isn't more than 4 years older than them, that this is voluntary and free from coercion, and that they're capable of self-sufficiency for themselves. And I will say that this year, Senator Elfreth in the Senate is the sponsor. And so these were some of there are amendments on here that made it through, that were negotiated with the Senate, I'll say last year. And we had voted this bill out last year, but this version includes some of the things that we had negotiated with JPR last year, and then we left early, so nothing happens. She believes that JPR is actually going to vote it out this week. So that is the hope, and that we'll never have to deal with this again.
Move favorable.
All right,
Thank
so
you.
we have amendments first. So can I get
the amendment.
amendments?
Thank you.
Can I get a motion on the amendments?
Move the amendment.
On the amendments.
Second.
And I hear a second. Okay. Are there any discussion? Is there any discussion regarding the amendments? Seeing Delegate McComas is waving her hand there, I think. So Delegate McComas.
Thank you, Mr. Chair. Just a brief question to the sponsor of the bill. Emancipation means that they can live by themselves and support themselves. Isn't that correct? Isn't that, you would know better than I because this is your bill.
Yeah, so the judge has to find that they are capable of self-sufficiency and self-support. But what I will say is because they're emancipated, they are not emancipated so they're still juvenile. So juvenile criminal laws would still apply. They still are required to finish school. They still can't consume alcohol and smoke cigarettes. So those laws still apply as it relates to their age, but they're emancipated for all other purposes.
So when you say they're emancipated for other purposes, what would that be? That
This is for the purpose of marriage. So if you remember last year, since I've been doing this so many years, last year I tried a full-on emancipation because I do believe that there are some situations where someone might want to be emancipated. But this year I just decided to just keep it tighter, and you can be emancipated for the purpose of marriage.
Okay, so you can be emancipated for the purpose of marriage. So you need the permission of your parents, correct?
Right, the judge just is the only person giving you permission, right? So we're removing the parent permission and the fact that you're pregnant saying that it's okay. It has to be, the judge has to find that it's in your best interest that you marry.
Okay, but they don't have to be pregnant, right? That's
Right.
okay. All right. Okay, all right.
All right, we're on the amendment. Are there further questions on the amendment? Seeing none, all in favor of the amendment, please raise your hands. Delegates Arakan, Lopez, Cham, Atterbury, Shetty, Williams, Griffith, Grammer, Conaway, Bartlett, Jones, McComas, Moon, Crutchfield, Carden, Fisher, Davis. All right, the amendment's adopted unanimous. We're now on the
Move
bill.
favorable as amended.
There's a
Second.
favorable on the bill and a second. Is there further discussion on the bill or further questions on the bill as amended? Are there further questions? Seeing none, we'll take roll call. The vice chair,
Yes.
Delegate Arakan,
No.
Delegate Bartlett,
Yes.
Delegate Carden,
Sure, yes.
Delegate Conaway,
Yes.
Delegate Cox. Delegate Cox. Delegate Crutchfield,
Yes.
Delegate Deborah Davis,
Yes.
Delegate Juanita Fisher,
Yes.
Delegate Grammer,
No.
Delegate Griffith,
No.
Delegate Rachel Jones,
Yes.
Delegate Lopez,
Yes.
Delegate Malone,
No.
Delegate McComas,
No.
Delegate Moon,
Yes.
Delegate Shetty,
Yes.
Delegate Cham,
No.
Delegate Ron Watson, I think is an HGO. Delegate Williams,
Yes.
that's 12. 12-6, so the motion passes. All right. Let's go to House Bill 306. It came out public safety. Vice Chair, are there amendments?
No, there are no amendments, and it was unanimous in the subcommittee.
Move favorable.
There's a
Second.
motion for a favorable and a second. We'll have discussion now on the bill for a favorable. Is there any discussion on the bill?
This was 306.
306, correct. So making a false statement to a law enforcement officer may form the basis of a hate crime if it is motivated in either whole or substantial part by another person's race, color, religion, sexual orientation, gender, disability, or national origin, or because another person is homeless. Delegate Arakan.
Thanks, Mr. Chair. I just wanted to just for a second explain, we did talk about this at length. We think this is already really not allowed, but this bill just clarifies it. And it's based off of that Central Park situation where the gentleman was bird watching and a woman straight up said, I'm going to lie to the police to get you in trouble, for whatever reason. I mean, she like straight Karen'd him. So that is what we're trying to address. And that's what this bill is about. And we still think that it's possible that the current law addresses the concern, but this just really clarifies it for judges that are and prosecutors.
All right. Are there further questions or statements about the bill? Seeing none, we'll do a roll call. The Vice Chair,
Yes.
Arakan,
Yes.
Bartlett,
Yes.
Carden,
Yes.
Conway,
Yes.
Cox, still, I think, away. Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanita Fisher,
Sorry, it took me a second to unmute. Yeah.
Grammer,
No.
Griffith,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
Yes.
McComas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Cham,
Yes.
Ron Watson is not back yet. Williams,
Yes.
that's 17. Okay. Go to Delegate Morgan's bill, 531. Delegate Morgan's bill has to do with lifetime supervision of people who are found to be guilty of child sexual abuse. Claire, I'm just making sure I'm getting that 100% right, correct?
Yes. Yes.
There are no amendments to the bill that I have. First, let me take a motion and then we'll hear from Delegate Fisher. Could I have a motion on the bill, please?
Move favorable.
Motion for a favorable. Is there a second?
Second.
And a second. All right, Delegate Juanita Fisher.
Sorry, I don't know why moving my mouse with my finger is taking me really long today. Mr. Chair, I just had a couple of just questions. I don't know if you could answer these or council. So have we voted on this bill before? Do we know, or is this the first time this committee has?
I'm
This is
not
the first time.
know if we voted on this in the last 3 years, but council can, I don't think we
It was introduced last year and we did not vote on it.
Okay, and this would put, and Claire, if you could clarify for me, so if you're found guilty of child sexual abuse, you would be on the registry for life, basically.
Yes.
And
Sexual abuse of a minor is,
for abuse of a minor, and there's no
Yes.
like gradation between the type of abuse or anything. It's just for any type of abuse of a minor.
well, you have to look at the elements of the crime. It's under 3602 of the criminal law article.
Sexual abuse
In the
means
bill.
an act, yeah. Sexual abuse means an act that involves sexual molestation or exploitation of a minor, whether physical injuries are sustained or not. Sexual abuse includes incest, rape, sexual offense in any degree, sodomy, or an unnatural or perverted sexual practice.
Okay. I think it's not that I'm opposed to this legislation, Mr. Chair. I think I was just asking these questions, you know, as this committee worked through jury service bill. I'm comfortable with the, I'm open to the bill. I wouldn't say comfortable. I'm open to the bill in the posture of that, but that's why I think a registry is not punishment, right? Like we don't serve out life sentences. There's not a life sentence on it. It's a registry. It's a public safety tool. So I think I think this kind of bill is really hitting that home because it's something you can never get off. It's for life, and it's fine that that's the policy of this committee. I just think it's a huge, I don't know. It's just what's in my mind. I'll stop talking now, Mr. Chair. Thank you.
No, you're all right. Okay, we'll go to Rachel Jones. Delegate Rachel.
Thank you, Mr. Chair. Thank you. Council, could you just clarify? It was my understanding that the bill it's less about the registry and more about lifetime supervision. I think the current law as it stands is that if someone is convicted of sexual assault or rape of a minor, 12 and under, they already have lifetime supervision. I think this bill just makes it so that if you are if you are under 18, but still 13 or older, you would get lifetime supervision, correct? So that would apply to everyone under the age of 18, not just 12 and under. Is that correct?
That's correct.
Okay. Thank you.
All right, Delegate Arakan.
Thanks, Mr. Chair. I've just had a couple clarifying questions for Claire. I thought that the bill had to do first specifically with, I think they're already registered for life. If it's with a trusted adult, I think that was one of the terms that we talked about. And then right now, they can get on probation for like a shorter period of time, but this would allow the judge to put them on a sort of probation for longer so they can monitor them for longer. It's like what Delegate Jones said, it's not just the registry that can, I think, already be done, but it's the probation that's getting extended so they can keep an eye on them. Is that right, Claire?
Yes, that's basically it. They would automatically be subject to lifetime sexual offender supervision.
Right. And then if this is specifically, does it reference like a trusted adult, like it would be like a parent or a teacher or someone in a position of authority?
That's, yeah, part of the elements of 3602, sexual abuse of a minor, on pages 1 and 2 of the bill.
Okay, so it's a limited, it's not just anybody who's committed any type of broad sex crime. This is very specifically a narrow window of people that have committed the most despicable crimes against children, that held positions of power over them or were a family member, like what we heard in testimony.
Yes.
Thanks.
Delegate John Carden.
Oh, I'm now on mute. Thank you, Mr. Chair. Just a couple quick questions. Maybe it's for Claire. First of all, this is for child abuse as opposed to sexual assault, right? Is that correct?
No, it's child sexual abuse, which is on pages 1 and 2 of the bill, which
Okay.
Chair Cliff just read over.
Right. So it's for child sexual abuse, not for sexual assault, which would be a different part of the code. Is that correct?
Well, there's 2 elements to the bill. The first deals with second-degree sexual offense, which is actually no longer a separate crime. It's been rolled into second-degree rape. So it would subject all instances of second-degree sexual offense to the lifetime sexual offender supervision. And then the other element of the bill subjects all perpetrators of sexual abuse of a minor, regardless of the minor's age, to the lifetime sexual offender supervision.
All right. So I have two more quick questions, Mr. Chair. First one is that we've already rolled second-degree sexual offense in, which means that there will be no one who will be convicted from here forward, actually, of second-degree sexual offense, because that crime no longer exists. So this is going to.
Well, actually, there could be if they committed the crime before October 1st, 2017.
Right. So it only because that was rolled in 2017, which means that anybody who committed a second-degree sexual offense prior to that is going to now be on the lifetime registry, lifetime supervision. Is that?
No, only if they're convicted after the effective date of the bill. So basically, if you committed that crime before October 1st, 2017, you would be prosecuted for second-degree sex offense because that was what was in effect at that time. But if you're already been convicted of that, then this bill won't affect you.
This won't affect you. So it's only a very finite number of people that part of the bill will affect. Okay.
Yes.
That's number one. Number two is if you can help me with sexual registry, the sexual offense registry versus supervision. Do you have to be on the registry in order to be able to get supervision?
Yes, it's only certain types of offenders, basically the worst offenders who get this lifetime sexual offender supervision. And you can actually, lifetime sexual offender supervision is a bit of a misnomer because you can petition off of it.
Right.
If you've been compliant and everything, then the judge can let you off of it.
Okay, but you're on the, if you are having supervision, you are also on the registry. And can you petition to be off the registry, or you can only petition to be off of supervision?
You can petition, under certain circumstances, you can petition for a reduction of the term of being on the registry, but in most cases, no, you can't change that.
And this is my last question, I promise. If I'm on the registry, or if somebody's on the registry, I won't use myself as an example, and they've been on the registry for 20 years, and they've petitioned, but they're denied. There's nothing they can do to get off the registry, even though they have shown complete rehabilitation and they haven't gotten in any trouble for over 20 years. Is that fair to say?
I'm not sure about I have to go back and reread the provision where you can petition to get your term reduced. I'm not sure about I'm not positive of the answer to your question with regard to.
Delegate Cardin, would you restate
year.
your question, because I may be able to help counsel.
Right. My question is, it's similar to the parole situation. If you've been on parole, if you went for a parole hearing, or you go for one of these hearings to try and get off of the registry, and you have done a yeoman's job, and the parole board believes that you are a good candidate, a good risk to take off of, to put onto parole, but the governor decides to deny that because for political purposes, it doesn't make sense to let somebody out of prison because of a heinous crime they committed. My issue is, these are people, some of these people, maybe not all, but some of these people are trying to get back into an area of normalcy. And I worry that if we leave it up to a judge's discretion as to whether somebody who committed a heinous crime 20 years ago, the judge does not want to put himself in a position to grant that, even if all evidence leads to the fact that this person probably should be given a second chance. Because if they're on that registry, they're not going to be able to find a place to live. They're not going to find a job. They're not going to be able to find a place to congregate with other people. It's going to be very difficult. That's my concern. This is a good bill in theory. I just worry about that unintended consequence. And that's my comment.
In 11.724 of the criminal procedure article, there's the process for petitioning to where a person may file a petition for discharge, and I'm assuming in the comments that he just made, he meant from lifetime sexual offender supervision. The person may file a petition. This is in 11.724F. And I'm going to start reading from 2. A person may file a petition for discharge after serving at least 5 years of extended sexual offender supervision. If a petition for discharge is denied, a person may not renew the petition for a minimum of 1 year. A petition for discharge shall include a risk assessment of the person conducted by a sexual offender treatment provider within 3 months before the date of filing the petition, and a recommendation regarding the discharge of the person from the sexual offender management team. The sentencing court may not deny a petition for discharge without a hearing. And the court also may not discharge a person from lifetime sexual offender supervision unless the court makes a finding on the record that the petitioner is no longer a danger to others. So there is a process by which they can apply to be removed from the sexual offender, from lifetime sexual offender registration. And that was I think the question that Delegate Cardin asked at the beginning of his remarks. So that does exist, and I understand what you're saying, that you want to provide for that opportunity later on. I think that the petition process does that. And with that, I'm going to go now to Delegates Davis, Conaway, and Arakan. So Delegate Davis, Deborah Davis.
Thank you, Mr. Chair. I share some of Delegate Cardin's concerns. The first thing is, this bill removes the judge's discretion regarding supervision. That's the first thing, correct?
No, there's no discretion. It's just requiring certain additional people to be subject to the lifetime sexual offender supervision.
Yes, so it requires, so the judge doesn't have an alternative, but they will automatically be under lifetime supervision, correct?
Yes, yes.
Okay. So that's my first concern. And I noticed that, Mr. Chair, that there's a distinction between lifetime supervision and the sexual, what do you call it, the registry?
And the registry? I mean, there's lifetime supervision and then there's the sex offender registry, and I can go into that here in a moment, but do you have a question?
Are they the same thing?
I think that somebody,
No,
they're not the same thing. No.
So would the code that you referred to wouldn't even refer to this, correct?
No, this.
petition
Yeah,
process.
this is the process. This adds them and Claire, correct me if I'm wrong. I'm wanting to make sure we're completely right with this. This goes to the lifetime sexual offender supervision, correct?
yes.
Yes. So this
Mr.
goes
Chair.
to the superintendent, which is what I just read.
Mr. Chair, I'd like to use my hold on this bill.
Okay, you'd like to hold it until the next voting session tomorrow.
Yeah, yes, Mr. Chair.
All right. Delegate Conaway and Arakan also wanted to speak. You can speak now, or you can just take this up starting tomorrow. Would you like to do that?
I would like to speak now.
All right, go ahead, Delegate Conaway.
Thank you, Mr. Chairman. I was wondering, could a person that's over 17 who has a sexual offense against a 17-year-old who's been emancipated, could they fall underneath of this law?
I don't understand the question. Say the question again, please.
If a person is over 18 and they have a sexual offense against someone who's 17 years of age but is emancipated, could they fall under this law? The 17-year-old, which would be included under this law, is emancipated. So would that come under this law as a crime against, I guess, juvenile? Or
Family member means a relative of a minor by blood, adoption, or marriage. So whether or not they were emancipated, I don't think has anything to do with whether they were still a relative based on blood. I think, yeah.
Well,
blood.
if they were emancipated, then they wouldn't be under your care.
That's also true.
Somebody under your care.
Because sexual abuse of a minor goes to a parent or other person who has permanent or temporary care or custody or responsibility for the supervision of a minor. And that generally would not be an 18-year-old over a 17-year-old.
okay, it would be a 30-year-old over a 17-year-old, right?
It would be the parent, probably, the parent.
Okay, a 40-year-old over a 17-year-old, but the 17-year-old emancipated.
Okay.
Emancipated, then presumably they wouldn't be under somebody's care.
Right.
Right. Okay. Thank you. Thank you very much.
Delegate Arakan, did you want to talk now or talk tomorrow? Probably.
Yeah, I just want
Go
to
ahead.
say a couple things. This bill does not change the existing law at all for the registry. So we don't need to, these offenders are already on the registry forever because of the heinousness of their crimes. So we're not changing that. And then the supervision is not all one thing or all another thing. The probation officer judges the situation and says, okay, this person's hasn't followed the steps we've already outlined for them. And so they need a higher level of supervision. Maybe they need weekly counseling, or maybe they need monthly counseling. And so the parole / probation officer sets up the type of supervision that's required for the person. So that's what this bill is doing. It's giving the opportunity to continue to monitor somebody who has raped their own children. That's what we're talking about. That was the case that came in here. And so that we can monitor this person to make sure that they are not, I don't know, having more children and raping those children too. So that is the actual purpose. This is a very narrow bill. It's not a huge amount of people that are raping their children. This is not huge. So I just wanted to make sure that we understood exactly what we're actually talking about.
All right, the vice chair, and then we're going to stop and we're going to move on.
Thank you, Mr. Chair. So I just want to say a couple things based on the conversation, and I agree. So we're not changing the law here. I think this bill actually closes a loophole, because right now the way the law is, it says if you have been a victim of 2nd-degree sexual assault and you are 11 and under, we care about you so much that we are going to put that predator on lifetime supervision. But if you are 12 to 18, we are not going to do that. And I have a problem with that. I have a problem with that because folks who prey and groom a child who is between 12 and 18, that takes a lot of more effort. And that is not a one-off. That is not a one-off, and they will continue to do that. I also take issue with the speculation that Delegate Cardin made that like these people are going to complete rehabilitation. We don't know that. We don't know that. And 2, that they have nowhere to live. That's not true. Go on the sexual registry in certain parts of the states and you'll see little dots all over the place. So they can find places to live. And just so everyone is aware, this crime is so significant that it's punishable for up to 20 years currently. And if the person is age 18 or older, commits something against a child who's younger than 13, you can be in prison for not less than 15 years. We're talking about forcing a 12 to 18-year-old, forcing them or threatening them without their consent, and you do a sexual act against them. We're saying somebody who is that age between 12 and 18, we're forcing you, if you have a mental disability, you're physically incapable of defending against yourself, or you're incapacitated, someone has forced a sexual act against you. So for all of those reasons, I will absolutely support this piece of legislation. Thank you, Mr. Chair.
All right, Delegate McComas, and then we really are going to stop. You're on. There we go.
Yes, sir. I was reading some of the testimony, and there's a really good letter from State's Attorney Aisha Braveboy that did a really good job saying what the effect, how successful they are having these folks on supervision versus on supervision and recidivism. So I just, I'm not going to read it, but I think everybody ought to look at that, and you would be persuaded that this is a good bill. And Aisha did have a letter of support of this bill. So that's all I'll say.
All right, we will take this back up tomorrow at our voting session. We're going now to House Bill 1000. House Bill 1000 is Delegate Pippi's bill regarding the property of minors or disabled people, and it's a prohibition on distribution or disbursement. Holly, can you just, for the committee again, I don't believe there are any amendments here, are there?
No amendments.
No amendments. Can you explain the bill?
Sure. So it just prohibits a guardian of the property of a minor or disabled person who is not a family member of the minor or disabled person from distributing property without authorization of the court if the disbursement would financially benefit the guardian or a family member of the guardian. And that's all the bill does.
Can I have a motion on the bill?
Move favorable.
Second.
Second.
And a second. Is there any further conversation about the bill? All right, seeing none, we will take a roll call. The vice chair,
Yes.
Erican,
Yes.
Bartlett,
Yes.
Carden,
Yes.
Conaway,
Yes.
Cox back. Not yet. Okay. Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanita Fisher,
Yes.
Grammer,
Yes.
Griffith,
Yes.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
Yes.
McComas,
Yes.
Moon,
Yes.
Shetty,
Yes.
Cham,
Yes.
Ron Watson,
Yes.
Williams.
Yes.
All right, I think that's 19. Yeah, should be 19. Okay. Now, we have two bills left to talk about, and let's start with 31. All right. This is a bill that would increase these are not in the right folder. Oh, well, they are not in the right folder. Sorry, one moment, please. Okay. I need to make sure that my folders are not completely befuddled. We have amendments to House Bill 31. We put the amendments on the screen, please. Oh, why is my sound out? Can you hear me?
We can hear
Yes.
you. Dylan, do you want to make sure it's the most recent one that I just sent you? It's going to be 316 at 144.
I got thrown out of my committee.
I was gonna say, I think the chair's gone.
All right, I think we're still streaming live, so first time for everything. All right. Let's try that again. This is House Bill 31. Dylan, could we please put up the amendments on 31? You might be having difficulty. No. All right, there's an interlineated version, and I think I can go through and talk about what the bill does as amended. As amended, this bill does a couple things. First, the Maryland Legal Services Corporation has a deficit for their funding for the next fiscal year. And that's in large measure caused by the drop in the revenue that they normally get, not only because there are fewer cases that are being filed, and you're going to see here in a moment where they get a surcharge for cases that are filed in circuit and district court, but also through they also get the interest that comes from lawyers' escrow accounts. And since escrow accounts have shrank, and since the amount of interest that's being paid on those escrow accounts have shrank, both of those things have come together to cost MLSC. So to that end, this does several things. First, if we could go down a little bit, a little more. There we go. Stop. Oh, slow down. Go back up. Thank you. Stop. There we go. All right. So right there on line 21, it would raise the cost of filing an action in circuit court from $55 to $85. That money would go to MLSC. Now we can go down a little bit. It also raises the cost to file a civil case in district court from $18 to $28, and that is in line 10. The part of this bill that has to do with the evictions process is above that on line 9, and it raises from $8 to $68 the amount to file a summary ejectment. Now, the total cost for summary ejectment with other fees that are included through the code. Right now, it's $15 to file a summary ejectment, so there's $7 in other parts of the code. $15 everywhere except Baltimore City. It's $25 in Baltimore City. The additional $10 in Baltimore City goes to fund the sheriff's office. So the $60 increase would raise the cost of a summary ejectment from $15 to $75, $85 in the city. The additional $60 would be split between a rental assistance special fund and the right to counsel and evictions special fund. Counsel and eviction special fund, you might recall, was also in House Bill 18, the right to counsel bill, Delegate Juanita Fisher's bill. The $30 rental assistance fund is a fund specific to this. And the idea here, and we can go to on page, where is it? On page 4 of the reprint. Right there, stop. The rental assistance special fund, the purpose of the fund is to provide funding to not-for-profit organizations that work in the area of rental assistance to pay the back rent for individuals facing a potential rental residential property eviction. DHCD would administer the fund. The money that is coming from the federal government is largely moving through there as well. So this would supplement that over time. And when the money that goes through that account goes away, at least right now, this money would sustain certainly a smaller fund. Right now, the feds are giving us a little over $1 billion. This would probably generate around $20 million a year, but it would create funds that could be distributed to locals to help pay people's rent. So that is the bigger picture of the bill. I will say that there was conversation about how many times there was an issue when we had the bill in the committee that dealt with whether or not the landlord should be able to recover these funds. Talked about it, had a small work group on this issue, and we talked about it. And the thought was that after the first 3 times that it was assessed against the landlord in a year, then the landlord would have to pay those. If it was a 4th time or more, they could assess those charges on the tenant. The argument being that if it was 3 times in a year, that's one thing that if a person is a little late a couple times, fine. But having said that, that if it becomes more chronic, that was different than that. We did not want this to be 3 times during the entire length of a tenancy or 3 times in the entire length of a person's rental. So they would have, that would be just 3 times in a year. So that's what the amendments do. Could I have a motion on the amendments to the bill?
Favorable.
So motion on the amendments. Is there a second on the amendments?
Second.
All right. Is there discussion on the amendments? Delegate Cardin.
Thank you, Mr. Chair. Just real quickly, does the money go to the tenant to pay the landlord in the rental assistance, or does it go directly to the landlord on behalf of the tenant?
So that would be something that we worked out by HCD. The idea is that they would have the opportunity to run the fund and would be able to expend the funds, as I read, to provide funding for not-for-profit organizations that work in the area of rent assistance to pay the back rent for individuals facing a potential rental residential property eviction.
Okay, I just wanted to clarify. That sounds great.
We don't get quite so far into the weeds as that, but we give them the ability, we're clear in the fund is saying
Right.
it goes to pay back rent.
It just seems to me that we want to at least make it clear through the language, I think it does, that they can't just take this money and say, okay, now I need to buy food. Not that they shouldn't have to buy food, but if it's intended for the rent, it should go towards the rent.
That's the intent of the fund.
The other question I have is, I didn't hear, or maybe I missed it. I know that circuit court fees go up. Do district court fees go up as well?
Yes, both district and circuit court fees go up. Circuit court fees would go from $55 to $85 for MLSC. District court would go from 18 to 28. If you look at the average cost to file a circuit court civil claim and a district court civil claim, it would put us almost exactly at the average for both.
Thank you.
So it gets us closer to the middle on those two. To be clear on where it goes on summary ejectment, it puts us at the average in the region. The national average is higher. Delegate McComas.
Thank you, Mr. Chair. I'll make this brief. I was reading some of the commentary by the witnesses, and it seemed like some of the major landlord-tenant organizations were suggesting that this be a lot less than what it is, and there's concern that Chief Judge having the authority to assess a surcharge may not be more than 60 per summary ejectment, which shall be deposited accordingly. My concern is that, you know, I know we have the Jared Kushners of the world, but we also have the little mom and pop that has one or two rental units that they use to keep, you know, to balance their finances, because all they have is Social Security. They don't have any 401ks or any other pensions or retirements besides Social Security. And I just think that this is like, it's a pretty large leap. And the other concern I have is we're going through a pandemic, but it looks like we're going to be coming out of this problem, and this is going to be all kind of locked in for a while. And and plus there's all this federal funds. The governor's been giving state funds, and I'm kind of concerned that we're going to harm the little people, and people are going to be. And the other thing that you have to realize is that a lot of people are buying up properties. In other words, you get cards in the mail every day. Oh, we'll buy your house, you know, no matter how bad it's falling down, sight unseen. And so a lot of people, this is going to be a disincentive to maintain property and just get out of the whole business. And so we may be literally closing a lot of the housing stock for renters. So that's it.
Delegate Griffith.
Thank you, Mr. Chair. A couple of questions. I think I may have touched on this during the bill hearing. Some of the concerns I've heard about this bill is there anywhere else where the government funds defense on a civil matter?
So you're asking if there's anywhere that the government funds the defense on a civil matter?
Right, because correct me if I'm wrong, doesn't some of this money go towards a defense fund for individuals?
So it goes towards the right to counsel fund. Yes. So, and we passed in House Bill 18, we passed the legislation that would that effectively creates a right to counsel in certain eviction cases.
Okay.
That's what the money would go to, the Maryland Legal Services Coordination and their corporation, and they would, with the assistance of a task force that's within House Bill 18, they would seek to put together the parameters of what that would look like consistent with the law, and they would work with local organizations to have those services provided to people.
And so is there any other area where the government provides those type of civil defense services?
Collections, custody, habeas corpus.
So yes, okay, good.
There are some, yes.
Okay, and
but if what you're talking about, there's a broader issue called Gideon. So Gideon in the criminal context is what says if you have I'm sorry, this is in a criminal context. If you're charged with a criminal matter, you have the right to counsel, and the state will provide you with counsel at no cost to you if you can't afford it.
Right.
There's been an issue in legal circles called Gideon that talks about whether that shouldn't be available for all civil cases too. That is not what we're doing in House Bill 18, but House Bill 18, certainly it's a civil issue. It's handled civilly, and we're hiring lawyers in certain specific cases for that.
Thank you.
Not generally. All right, Delegate Malone, then Delegate Cham.
Just further, still trying to clarify. So under this bill, the landlord will not be able to recover from the tenant the filing fee for certainly for the first and the second, correct?
Say that again.
The landlord will not be able to recover from the tenant the filing fee for the first and the second filing.
It's the first three.
Okay.
Lord
All
would
right.
be responsible for the first three.
The fourth one, can they then go back and get the money?
They could ask the tenant for the fourth one if it did not happen, if it happened in the same year.
But only the fourth one.
No, it's anything above the fourth one. So it would be 4 through 12 if they did it every single month.
Okay, so January, tenant doesn't pay. Landlord files, tenant pays. And the landlord can't recover. February, tenant doesn't pay, landlord can't recover. March,
Correct.
Tenant doesn't pay, landlord can't cover. April, tenant doesn't pay, landlord could recover for the fourth, but at that point can't recover for January, February, March, correct?
Correct.
So if you think you're going to have a bad paid tenant, you better build in 68 times $3 because you're certainly never going to see it because you have no legal right to see it.
I mean, it's fair to say that I think fairly clear that landlords also include late fees in their leases as it stands. So it would not surprise me if they didn't put late fees against tenants, and that's one of the other challenges that tenants have to face in these situations. I think the idea behind this part of the bill was to try and find, because this was an issue that was raised during the hearing, about whether or not the fees should be ever assessed against a tenant.
I understand, Luke. I understand.
Yeah, I mean, the challenge is that there are those people who don't want it to be ever assessed against a tenant. The landlords want to have some way of going forward. I think that my argument here would be is that it is a relatively rare or certainly not as ubiquitous as the 660,000 times that they were filed. I'm not saying it doesn't happen, but I'm saying that if it happens, it's rarer than what happens now. And furthermore, I believe that what we've done in the bill that passed today in House Bill 52 is we've built in 7 days prior to somebody being able to file the summary ejectment in the first place to provide them notice and say, hey, you've got to pay your rent or I'm going to district court. Creating that buffer as well, I believe, will limit the number of times and will begin to knock down the number of times that people file that summary ejectment in the first place. Added on top of all of that, we have the lowest summary ejectment costs in the country. And so the part that I become more concerned about more than anything is using district court effectively as a collections mechanism for people. That to me is the bigger problem. Having said that, the idea was to find some kind of a middle ground between the two positions, and that's what the amendment seeks to do. So I'll go to Delegate Cham and then Delegate Moon.
Thank you, Mr. Chair. We've had quite a few of these bills come through committee, regarding helping Marylanders with, eviction notices and they can't pay their rent and things of that nature due to the pandemic, rightly so. So do these bills operate in silos of each other, or if they pass? Or would the person who is in need of assistance be able to kind of use all of these different bills to help them pay their rent? Or can they just, it's quite a few, I think 52 and 1312 and now this one.
Yeah, MLSC does provide some services to help people identify the local not-for-profits that could be able to help them with specific issues. And one of the things we did on House Bill 52 is we made that change at the end where House Bill 52 says that if you are that it didn't list MLSC's number. It basically said you could take from a list of providers that MLSC has, and these are the people who, at least after we pass these bills, could help provide rental assistance, could provide legal assistance. So do they operate in silos? They're in different bills, but I don't know that they necessarily are in silos. And furthermore, with regard to the fee bill, this ties into House Bill 18, into the right to counsel. So that they do tie together in some way. Delegate Moon.
Thank you, Mr. Chair. I just want to respond to Delegate Malone's concern. And his line of inquiry was really jogging my memory, and I think it's very important here. So Delegate Malone is concerned about the scenario where essentially we're letting tenants off the hook for eviction fees and hanging that on the landlord. But I'll remind folks that I believe it was in 2015, we had a bill, this would have been my first or second year down here, we had a bill that would have raised civil filing fees. And guess what happens to it? We had Delegate Shalega on the floor of the House attacking the bill, saying that increasing filing fees in Maryland means you are sticking it to tenants being evicted, and that they were the ones who were going to end up absorbing the cost of any increased filing fees if we do that. And that bill ended up failing on the floor due to that argument, when some Democrats, the Republicans were interested in just stopping any fee increase, and some Democrats were sympathetic to this argument of those fees being passed on to tenants being evicted. And so they joined. And, for folks who were around then, you remember it was a little controversial. We had conversations about the bill and we revoted it. And so it came back. But here we are again a few years later, and we have a bill coming up, and it's increasing filing fees with the intent to help the tenants being evicted. So no, we are absolutely not going to let you come back around and have it both ways on this argument. Move the previous question.
There are a couple more people who want to talk, so we're going to hear from them. And Delegate Malone did want to have a second bite, so we're going to do that. Delegate Malone, then Delegate Griffin.
Well, first, I believe Shalega's argument is still completely sound, because the reality is it increases the overall cost to the landlord, and therefore the landlord's going to pass it on to the tenant. So I still think it's sound. But the second part of the question I wanted to ask earlier is, and maybe this is for counsel, as I understand it, if you file an action and the tenant pays before you get to court, that doesn't count as one of the right to redemptions. It doesn't count as one of the 3 strikes you're out.
Because they cured.
Because they cured before you even got to court.
Right.
So you could have a tenant over a course of a year is late every month, and every month you must file to get their attention, but every month they do pay. And then that will mean, because you can't collect the filing fee, that's just an increased cost of doing business. Just making sure I understand it correctly.
I'm
Correct?
sorry. Give me the question again, because you cut off my end a little bit.
You sign up a tenant.
Right.
Unfortunately, you don't know that they're going to be a bad pay because they just can't seem to grasp that they're supposed to pay their rent on time. The only way you can get their attention is filing a rent action. So you file rent action, but then that does get their attention. They pay their rent before you go to court. And they do this every month. None of those foreclose the right of redemption though, because they pay before court. And that's what I'm looking to clarify that.
I mean, under,
That's the case.
if they
Well, that's what I'm
filed
asking.
if they filed it 3 times and then they paid 3 times, on the 4th time, they could assess them the fee.
Okay,
One-
just by filing, not by going to court. You don't actually have to go to court. That's what I'm trying to understand. Do you actually have to go into court, or can somebody cure before they even get to the courthouse, and that doesn't count towards the 3 strikes?
No, I believe that as the way the bill is drafted, that would count towards the 3 strikes.
Okay, that's what I'm looking to know. Thank you.
I also want to add, there's still the
Yep.
late fee that the person's paying. I feel like Delegate Malone keeps doing the scenario. That person would have been charged a late fee each time they paid late, and you have up
Yeah,
to.
good. Pay your freaking rent.
I know, but you said there's no tool to get them to pay. You have the late fee.
Well, I guess they need to
You said there was no tool. There is. It's called the
Well,
late.
okay, you're removing a tool to speak correctly and correctly. A tool is being removed now.
All right, Delegate Griffith and Eric Can.
Thank you, Mr. Chair, and Delegate Moon is my muse once again. And he brought up a point that I was going to bring up, but it's very true. You know, the only businesses that don't pass on fees and taxes to their consumer are bad ones, especially ones that operate at very, very small margins, like many small mom-pop property owners who are renting or leasing property to folks. You know, so to think for, I don't know how we can assume or even state that that's not going to happen in this scenario, because it absolutely is, because the P&L for a small property owner does not change. They got to hit their P&L, and they're just going to increase the cost, which will get passed on to the tenant, and that's absolutely going to happen. I don't know how we can debate that's not going to happen. So it's not a tactic. It's what I would do. It's what probably every one of us would do if we were in the same situation. Those of us property owners probably end up doing the same thing, because, we can't, I'm not a landlord or anything, but, for any business, I just don't see how that's not going to happen. So I just wanted to put that out there.
Delegate Eric Can.
Thank you, Mr. Chair. Yeah, I'm just going to echo what Delegate Griffith just said. I am the landlord that we're discussing that would be impacted by this. I have not raised the rent on my Baltimore County property in years because I like my tenant, and I have not charged late fees for that property, even though the rent for a long time would come a few days late. But again, I like my tenant, so I don't do that. But this year has been particularly chilling for landlords like myself. And the second that my tenant tells me that he's moving out is the minute that I will put my property on the market, because this is not going to be tenable for small business owners like myself who we pay the mortgage with the rent. So, we're not making money off of this. This is a long-term investment for my husband and I, for the day down the road when the mortgage is paid off, for us to have a small income from this property, because we don't have big retirement funds because we're all self-employed. So I am sad to say I look forward to the day when I eventually sell that property and buy one in Pennsylvania.
All right, are there further questions? We're now on the committee amendments. We're not on the bill itself. Are there any further questions on the committee amendments? Right. I thought I saw something flashing on the screen. All right, so again, what the bill does, well, I've already gone through what the bill does. Don't need to do it again. All right. Seeing none. On the bill, or I'm sorry, on the amendment, and the amendment has been seconded. I want to be very clear. When it comes to the issue that we've been discussing, this is it should say that it's the first 3 payments in a year. And can I ask council just to be clear that that's what the language is that we've got as part of this amendment?
Yes, and it's in 3 different areas, but it does say in a year, and it's just conforming it to the rest of the code. So it's also in the real property section, and there's actually 2 real property sections where it's just clarified. But yes, each instance says in a year.
Okay, in a year, so not all together forever.
Exactly.
All right. All right, on the amendment, all in favor of the amendment, please raise your hands. All right. I'm looking here. I see my pen does not work.
Can I hold this
you-
bill?
I'm sorry, you want to hold the bill? We're in the middle of a vote on the amendments on the bill.
Oh, sorry. Okay. Yeah, okay.
Okay, on the amendments, raise your hand if you're in support of the amendments. Delegates Moon, the vice chair, Lopez, Cardin, Conaway, Williams, Shetty, Fisher, Davis, Crutchfield, Jones, Bartlett, and Watson. All those opposed to the committee's amendments. Delegates Arakan, Malone, Sham, McComas, Grammer. And I don't think I see anybody else. And Griffith. So the amendments are adopted. We're on the bill as amended.
All right, move favorable then.
A motion for a favorable. Is there a second on the motion for?
Second.
Motion for a second. Is there further discussion on the bill as amended? Seeing none. Vice Chair,
Yes.
Arakan,
No.
Bartlett,
Yes.
Cardin,
Yes.
Conaway,
Yes.
Cox, not here.
Only get it.
I'm sorry? Crutchfield,
Yes.
Deborah Davis,
Yes.
Juanika Fisher,
Yes.
Grammer,
No.
Griffith,
No.
Rachel Jones,
Yes.
Lopez,
Yes.
Malone,
No.
McComas,
No.
Moon,
Yes.
Shetty,
Yes.
Cham,
No.
Ron Watson,
Yes.
Williams.
Yes.
All right. 13-6. Okay, so that's 31. We'll go now. 523. We talked about this a great deal previously, and there are 2 further amendments to the bill. Can we put those up on the screen? All right. So, well, could we have the amendments actually, the 2 amendments?
Can we make it bigger?
520, they take All right, well, we'll get them on the screen. They're going to be relatively short. So one of them addresses an issue that Delegate Malone raised with regard to the lead paint database and the effective date of this bill. So one amendment would make the effective date January 1st, 2022 to allow the database to take place, to be in place and not have a month or so of overlap when it's not. The other amendment has to do with an issue, and Dylan, if you can, this is 482710/1. And it
Question
basically
on the First Amendment.
all right, that's fine. We'll do the first question about the First Amendment. Delegate Conaway.
Thank you, Mr. Chairman. So with the database, will the person renting the property be able to look to see if the property has been lead inspected?
Will which person?
The tenant, potential tenant.
The potential, my understanding of the database is that they're creating a database so that that information would be available to the court and that it would be a public database.
Public database, thank you.
To make sure that it was available. So there's the first one. And then the second one, and counsel, I'm going to ask for your help in talking about the second of the two amendments.
Yeah, so the second amendment's going to be on page 4, and it basically strikes, if you see the amendment, C2 Roman numeral 1, the information required under subsection B1 Roman numeral 6. That is in reference to the regulations that are in the database. So, and it says they may not be an issue of fact in trial. Basically, leaving this in makes the requirements of Roman numeral 2 moot. So that needs to come out so that the landlord is actually obligated to show that information. So we're going to strike that, and the rest is conforming. The reason this amendment doesn't look like it should is because it's an amendment to an amendment. And so it'll be drafted into the bill when it finally moves out, if it should, out of the committee. So that's why you're seeing it doesn't have all the conforming Roman numerals that will also be in that amendment too. So that's all the amendment does.
All right, and the issue here is, it goes to the issue of the lead certification. So it would allow it to be an issue of fact in the trial as to whether or not they had the ability to file the summary ejectment in the first place, because that's the sum and substance of the bill, isn't that? Am I reading that right, Holly?
Yes, that's correct. And that is that section B1. So it's very narrow, but in order for this bill to really have any substance, that line needs to come out.
Okay. Delegate Conaway. Delegate, oh, you're taking down your hand? Okay.
That was from the last question.
Oh, it's from the last one. Okay, that's fine. Delegate McComas.
Just real quick for clarification, under the part that you're striking, the information required under subsection you're striking out, Roman numeral 2:1, during the trial, the landlord shall have the burden of proving. That stays in, or does that go out?
That's gonna stay in and move up, Delegate. That's gonna be the new Roman numeral 1. But because it's an amendment to amendment, technically I can't do that in my system, so it'll be finalized, but that'll be moved up, and the rest will be conforming to make sure that that subsection aligns up correctly.
Okay, I wasn't sure, because the way you said, if the landlord fails to provide the proof of item, of the paragraph, he can't enter the judgment. But anyway, I get it. I kind of missed that it was just moving up. I thought you were striking that out too. Okay.
Exactly.
Delegate Juanita Fisher.
Move the amendments, Mr. Chair.
All right, there's a motion for the amendments for both amendments. We'll take them both at once. I think that's fine.
Second.
And there's a second. Any further discussion on the amendments? Seeing none, we'll go ahead and take a vote to add these two amendments. So all in favor of these two amendments, please raise your hands. Delegates Conway, Arakan, Griffith, Malone, Lopez, Cardin, Moon, Atterbury, Grammer, Williams, Shetty, Fisher, Davis, Crutchfield, Jones, Bartlett, Watson. Any opposed? McComas, Cham, McComas and Cham. All right.
Move favorable.
Now we're on
Second.
as amended, and there's a motion for a favorable and a second. Is there further discussion on the legislation? All right, seeing none on the bill as amended. The vice chair,
Yes.
Delegate Arakan,
No.
Delegate Bartlett,
Yes.
Delegate Cardin,
Yes.
Delegate Conaway,
Yes.
Delegate Cox is not present. Delegate Crutchfield,
Yes.
Delegate Deborah Davis,
Yes.
Delegate Juanika Fisher,
Yes.
Delegate Grammer,
No, and to explain my vote briefly, we're using laws that should prevent properties from being rented. We're ignoring them, allowing slumlords to rent them, and instead using that same law to prevent the private property owner from repossessing his property. I think our housing policies are backward, and that's why I'm voting no.
all right, Delegate Griffith,
No.
Delegate Jones, Rachel Jones,
Yes.
Delegate Lopez,
Yes.
Delegate Malone,
No.
Delegate McComas,
No.
Delegate Moon,
Yes.
Delegate Shetty,
Yes.
Delegate Cham,
No.
Delegate Ron Watson,
Yes.
Delegate Williams.
Yes.
All right, 13-6. Okay, there are two other matters that were somewhere on this desk that I needed to deal with. There were two bills that were special ordered today. We'll start. These are going to be floor amendments, one offered by Delegate Crutchfield on her bill 1121 and one on my bill. It's the Juvenile Council bill, and that's 1187. So if we could put up 1121, please, for Delegate Crutchfield. There was a typographical error that she missed. She did not mean to specifically identify the Maryland Public Policy Institute. She meant to say Public Policy Institute in the state would be responsible for engaging in the work that would be done to identify evidence-based programming. Delegate Crutchfield, did I represent that?
You did.
All right.
Move the amendment.
Thank you.
All right, there's a motion and amendment, motion to make this to accept this as a friendly amendment on the floor, and a second. All in favor of making this a friendly amendment on the floor, please raise your hands. Delegates Conway, Arakan, Griffith, Malone, Moon, Cham, McComas, Cardin, Lopez, Shetty, Williams, Grammer, Atterbury, Bartlett, Jones, Crutchfield, Deborah Davis, Juanika Fisher, Ron Watson. The amendment carries. I don't see anybody not raising their hands. The next one is in 1187. This is in the Juvenile Council bill. In the original Juvenile Justice Council, it left room actually for 3 members of the Senate and the House to be part of the council. This would allow for 2 members of the Senate and the House to be appointed to the new commission that would be there. That was an oversight, and I want to make sure that there is some representation of the legislature on the commission. Could I have a motion to accept this as a friendly amendment on the floor?
Move the amendment.
Motion.
Motion and a second. Any discussion? Seeing none, if we could go back to the big screen again, please. All in favor of this as a friendly amendment on the floor, please raise your hands. Delegates Conaway, Griffith, Malone, Lopez, Cardin, Comus, Arakan, Sham, Moon, Atterbury, Grammer, Williams, Shetty, Fisher, Davis, Crutchfield, Jones, Bartlett, and Watson. And seeing no one having not raised their hands, the amendment is adopted. All right. Here's what we've got coming up here on the Judiciary Channel. Really should think about that, making this the Judiciary Channel. Tuesday at 4:30, that's 3:30 Central, 1:30 Pacific. The Civil Law Subcommittee followed, subcommittee chairs will be meeting separately at 7 o'clock tonight. Tomorrow at 9:15, the Criminal Law Subcommittee will be meeting. We'll have a vote session approximately at 2 o'clock. It's going to depend on how long the voting on the floor goes tomorrow. There will be 2 sessions tomorrow. Thursday, so in any case, there will be a voting session in between the 2 floor sessions tomorrow. Thursday at 12:30, the Public Safety Subcommittee will be meeting. There are other times being held for subcommittee if we don't finish the work on the floor, if we get pushed into overtime. So those times may move around so that we can be flexible with floor schedules as we are able to be on the floor a little bit longer now. With that, thank you all very much. That concludes the voting session for today here in the House Judiciary. Thanks very much.